good afternoon, and welcome back to Thorough Newspaper Analysis. Today is 17th of June, and this entire video series, it's brought to you by LawSikho. So now let's head to the agenda for today. First, we have the editorial segment, where this is the article that we've taken up for our discussion. It is titled as Where Anyone Can Be Accused of Sedition. Here, essentially, the authors are trying to advance a case against the recommendations that have recently been made by the Law Commission in its report on retention of sedition law. The second segment for today is the news update segment. And thirdly, we have a look at important legal developments of the day. So with this, let's dive into the TNA. And the first point of discussion would be this article. Let's understand the why of this article first and have a look at what have been the amendments that have been proposed by the Law Commission. So the 279th Law Commission report, it lays down grounds for retention of the sedition law, and these grounds are threefold. First ground, it states that the essence of the Supreme Court's verdict in the case of Kedarnath Singh, it should be inculcated and incorporated under the sedition law, which is section 124A of the IPC. Let's understand as to what is the essence of this judgment. I would like to read from the Law Commission report itself, which says that the test laid down by the Supreme Court in Kedarnath judgment, it is a settled position of law unless the words used or the action in question do not tend to incite violence or to cause public disorder or cause disturbance of public peace, the act, it would not fall within the ambit of the sedition law. So in this particular case, it has been categorically stated that whenever the offending word or the offending action, it is questioned and we have to decide whether it falls within the ambit of sedition law or not. We have to see whether it has the tendency to incite violence, to cause public disorder or to cause disturbance of public peace. The second amendment that have been proposed is the enhancement of the minimum punishment. And thirdly, it has been stated in the report that whenever any complaint with respect to a matter being seditious has come to the forefront to the police, then before registering an FIR, the police has to conduct a preliminary inquiry, and the police officer should be somebody who holds a rank of an inspector or higher. Now let's understand as to why the author says that these three recommendations, they are flawed. First, let's take up this recommendation. Here, against this recommendation, the author has essentially said that this tendency jurisprudence, it is very ambiguous standard for any judicial and executive mind, because the Law Commission report, what it essentially has done is, the commission claims on the one hand that only those forms of expression will be penalized which have a tendency to incite violence. But it muddies the legal waters further. How? By adding that tendency would mean mere inclination to incite violence rather than proof of actual violence or imminent threat of violence or threat to violence. So what essentially this means is the word tendency, that whether a matter is seditious or not, we have to see whether it has the tendency to incite violence. So tendency has been defined a mere inclination to incite violence. There need not be an actual or eminent proof of a violent act having taken place post the incitement. The mere incitement is sufficient. So this is the problem that the author has highlighted, that this tendency jurisprudence, it is very broad, it is very ambiguous standard for judicial and executive mind. Now, as far as the third amendment is concerned, the conduct of preliminary inquiry, the authors essentially are aggrieved by this because they say that now the police have to judge a particular act on mere inclination to violence, and no proof of violence or even actual threat of violence is needed. The Law Commission's proposal, it will cast a very wide net on any act that appears to be seditious. Further, the authors have stated that the proposed amendment, it asks the police to not only look for imminent threats to violence or proof of violence, but also anything that has the mere tendency to inciting violence. So therefore, the police, they have now been given a very wide range of powers, and it further paves the way for police to rein their power. If the recommendation it is enforced, then the social stigma of being a traitor, it would be coupled with the pre-trial provisions which favor incarceration and a lengthy legal battle. And therefore, the author says that this takes us to the colonial times when the political parties, they used to reign, and the subjects were suppressed constantly. So this now also is sort of a replica of the colonial relic that we had to live under for so many years. And with this, the author end this particular article by saying that no linguistic change and procedural reform can remedy the problem that the sedition law itself poses in a post-colonial democracy. And with this, we proceed to the next segment now. And now we proceed to the national news category for today. RBI opens sub-office at Kohima to increase presence in Northeast. The Reserve Bank of India, it has opened a sub-office at Kohima and has announced its aim to soon have an office in Itanagar for the purpose of strengthening its presence in the Northeast India. The Northeastern region, RBI is currently present in Assam, Manipur, Meghalaya, Mizoram, Tripura and Nagaland. The Kohima sub-office, it houses the Financial Inclusion and Development Department, the Consumer Education and Protection Cell, the Market Intelligence Cell and Human Resource Management Department. This is while the currency management for Nagaland, this will continue from Guwahati office. Next, we have another update which is essentially relevant for the financial cluster of courses. India's first microcap fund launched amid the rising investor interest in small cap funds. Motilal Oswal Asset Management, it has announced India's first microcap fund, which will invest in companies that are even smaller than small caps. The passive fund, it will track the Nifty Microcap 250 index, which essentially measures the performance of top 250 companies, excluding those that are already present in the Nifty 500 constituents. Moving on to an update in the defense sector for today. INS Vikramaditya, it is back in action. Navy to get 2 more Romeo helicopters. With the expected delivery of 2 MH-60 Romeo anti-submarine warfare helicopters later this month, the Indian Navy, it is poised to improve its operational capabilities. These helicopters, they will be stationed on the INS Vikramaditya, which just finished a protracted refit that lasted almost 2.5 years. It is anticipated that the delivery of the helicopters, it will take place during the Prime Minister's official visit to the US. India makes its debut at Annecy International Animation Festival. India, it is participating at the Annecy International Animation Festival for the very first time this year. India, it has lately emerged as a preferred destination of VFX and animation content for global production houses. The animation and VFX market in India, it is valued at around rupees 109 billion, and this was the figure for the year 2021, with VFX business alone amounting to a massive rupees 50 billion chunk. This figure, it is expected to grow to 180 rupees billion by the next year, according to a report by EY. India's participation at this particular festival, it therefore assumes of greater importance as the country showcases its abilities in the sector to international buyers. And this has brought us to the international segment for today. The United Nations General Assembly, it has adopted a draft resolution which was introduced by India for the purpose of establishing a memorial wall in the UN headquarters to honor fallen peacekeepers. India's permanent representative to the UN ambassador, Ruchira Kamboj, introduced the draft resolution, which was titled as Memorial Wall for Fallen United Nations Peacekeepers. This was done in the United Nations General Assembly Hall. The resolution, it was co-sponsored by nearly 190 UN member states, and it was adopted by consensus. Russia's Sberbank, it launches Indian Rupee accounts. Russia's dominant lender, it stated, individuals could now open accounts in Indian rupees, expanding the range of foreign currencies available as Moscow, it strives to reduce dependency on US dollar and euro. Sberbank, it has more than 100 million retail clients, and it already offers deposits in currencies of China and UAE. Rupee accounts, they would be available from Wednesday onwards. The third update in the international segment is this. EU approves draft law to regulate AI. It is worth noticing that this regulation, it is entirely framed around the notion of risk, and it is not AI itself that is being regulated, rather the way it is used in specific domains of society, each of which carries different potential problems that has been dealt with here. The four categories of risk subject to different legal obligations are unacceptable, high, limited, and minimal. Systems deemed to pose a threat to fundamental rights or EU values, they will be categorized as having an unacceptable risk and therefore will be prohibited. And this has brought us to the legal segment for today. The first update comes from the Honorable Apex Court. Railway not liable for theft of passengers' belonging. Supreme Court set aside Consumer Forum's award. The Honorable Supreme Court, it has held that the theft of personal belongings of a passenger, it is not deficiency of service by the railways. Accordingly, the division bench, it set aside orders that were passed by the Consumer Forum, whereby railways was directed to reimburse the stolen amount of cash to the passenger. The name of this particular matter is Station Superintendent and another versus Surender Bhola. Another update for today in the legal segment is also coming from the Honorable Top Court, wherein it has been held that approver need not be examined as witness by the magistrate when cognizance it is taken by special court under the Prevention of Corruption Act. The Supreme Court, it has held that when the special court chooses to take cognizance directly under Section 5, subsection 2 of the Prevention of Corruption Act, then the question of approver being examined as a witness in the court of the magistrate, which is required by Section 306, subsection 4, clause A of the CRPC, it does not arise. The name of this particular matter is A. Srinivasulu versus State represented by the Inspector of Police. And with this, we've come to an end of the TNA for today. In case you want to get access to the free study material that LawSikho provides or the TNA slides that have been used in this video, I would highly encourage all of you to please join our Telegram channel. And for the very same purpose, you may scan the barcode here or you may click on the link which is provided in the description. These are the point of contacts in case you want to get in touch with LawSikho. The daily quiz, the link of the same is made available in the description of today's video as well. Please go ahead and attempt the same. Thank you for being with us.